Hello friends, I'm Sanjay. In this series, I'm solving and explaining the CLAT PG 2024 question paper from the exam that was conducted in December 2023. This is part 3 of the series and I will cover the third passage and the 5 MCQs associated with it. You should watch this series from part 1 in which I have given a brief overview of the approach that I'm taking with this paper and also why the elimination strategy is very important in this exam. The questions from the first passage were somewhat complicated and required quite a bit of guesswork. Questions in the second passage were quite easy, and the questions in the third passage are reasonably straightforward. You will also see that some of the questions can be answered by just applying a little bit of logic and common sense to the answer options. This passage is extracted from a landmark case from 1969, that is A.K. Kraipak versus Union of India. This case was about the selection of officers into the Indian Forest Service. At the time of this case, each state would have a selection board that would recommend the candidates from among the eligible officers of that state's forest department. And the selection board would be headed by the respective state's chief conservator of forests. In this case, a person had been appointed as the acting chief conservator of forests for a state. And because of this designation or office, he was heading the selection board for that state. Incidentally, he was also a candidate for the Indian Forest Service. When the results were announced, he was one of the selected candidates. Some of the other candidates who had been rejected approached the court. Because the person who was the head of the selection committee was also a selected candidate, the court applied a principle of natural justice that no person should be a judge in his own case. While this person contended that he was not present when his own candidature was being discussed, the court held that his presence as the head of the selection board would influence the judgment of the other members and lead to a situation of bias. The other point that was brought up by the defense was that the selection process was not a judicial or quasi-judicial process, it was merely an administrative function. So the principles of natural justice were not applicable in this situation. On this point, the court ruled that the principles of natural justice would be applicable on judicial, quasi-judicial and also on administrative functions. Question number 11 is asking which of the following propositions or statements is the reason why the A.K. Kraipak case is considered to be a landmark case. The first statement is saying that the principles of natural justice are not applicable to purely administrative functions. This is an incorrect statement. As you can see here, the court is stating that it fails to see why the principles of natural justice should not be applicable to administrative functions also, especially because arriving at a just decision is the aim of both quasi-judicial and administrative inquiries. So this shows that the court disagrees with whatever has been mentioned in option A. So option A can be eliminated. Option B. The principles of natural justice are in an ever-evolving state of flux. This is supported by the statement in the passage that the concept of natural justice has undergone changes in the recent years. But this is not a landmark statement. For example, if I make a statement that the Indian society is in an ever-evolving state of flux, it just means that our nation is constantly undergoing change. It is common sense. It is not a landmark statement. Option D is stating that there is no application of the principles of natural justice to quasi-judicial functions. This is completely incorrect because one of the main arguments in this passage is that these principles are already applicable on judicial and quasi-judicial functions. So why should they not be applicable on administrative functions also? The remaining option is option C, which is the landmark ruling in this case, that the principles of natural justice do not differentiate between administrative and quasi-judicial functions, and they are applicable on both of them. Since we could answer this question using the information given in the passage itself, this is a direct question. In question 12, we are asked to identify which of the given approaches to interpretation of statutes is the court using. What is the interpretation that is being done here? Well, the principles of natural justice are standards of conduct or standards of judicial behavior, which were mostly codified in the ancient times. For example, the principle that no one shall be a judge in their own case was originally codified or written in Latin in the Roman times in 376 AD, and it was later formally documented in English law in the 17th century. These judicial precedents, where the principles of natural justice were used, were followed by the English justice system and later the Indian judicial system, which followed the English legal systems. Based on these precedents, these principles were generally applied in judicial proceedings and quasi-judicial proceedings only. But in the A.K. Kraipak case, the court interpreted that these principles of natural justice and these precedents are applicable to administrative proceedings also, which means that the court was not just literally following the words of the principles or strictly following the precedents set in the previous decisions, it extended them to cover administrative process also. The court was using a constructive or purposive interpretation approach to interpret the principles and understand their goals, which is to avoid any kind of bias in official functions. And these official functions may be judicial, quasi-judicial, executive or administrative functions. Therefore, the correct answer is option B. This is an external question, since it can be answered using your awareness of the various rules of statutory interpretation. In question number 13, we have been asked to identify which of the given rules of natural justice was a later entrant to the principles of natural justice. Here we have to understand the question properly. It is just asking us to identify which of the given three is the later entrant. So none of the above can be eliminated. Now look at the information in the passage. It says that rules 1 and 2, which are that no one should be a judge in their own cause and that no decision should be taken against a party without giving a reasonable hearing, were thought of as the only two rules of natural justice, and later other rules came to be added, which means that options A and B were already in existence from the ancient times, and option C, that is the duty to give reasons, was added later. Now the duty to give reasons implies that the decision maker must provide an explanation for their decision, which allows for greater scrutiny and appeal of the administrative decisions. It emphasizes the importance of transparency and accountability in the decision-making process. Since the correct answer, C, can be identified easily using the information within the passage itself, this is a direct question. In question number 14, we are asked if there is a need for an urgent emergency action and the situation does not allow for the principles of natural justice to be followed. Which of the given options is true in such circumstances? I want you to pay attention to the answer choices because there is more than one correct answer here. In questions like this, we have to choose the best answer from among the correct answers. To understand this question, imagine a situation like an earthquake or a flood, which is an emergency, and the government has to take some administrative actions to provide immediate relief to the people. In such an emergency situation, it may not always be possible to follow all the principles of natural justice. But the officials who are taking such actions should record as to why the principles of natural justice could not be followed in those situations. Later on, after the emergency has been dealt with, a hearing can be held where the details of the previous actions are considered. The reasons as to why the principles of natural justice were ignored will also be considered, and a remedy can be provided to the people who were negatively affected by the administrative actions. When we read the answer choices, options A and B are similar, but with one important difference. In both options, the administrator may choose not to follow the principles of natural justice. In such a situation, option A says that the reason for not following the principles need not be recorded in writing. Option B says that the reasons for not following the principles must be recorded in writing. In any government organization, records are very important because officials may be transferred, officials may retire, officials may pass away, and the reasons behind any important actions may get forgotten and lost with time. If it is written and documented, the reasons will remain accessible and can be used in the future. So between A and B, B is correct because the reasons must be recorded in writing. Option C is also correct, and it is actually more important because it says that if a pre-decisional hearing, that is a hearing before the administrative actions are decided, was not possible because of an urgency or an exigency, then a post-decisional remedial hearing may be provided. Between B and C, which is more important? While recording the details is important, just recording something is of no use unless the information is used to provide a remedy to the affected people. So, post-decisional hearings are more important. Therefore, option C is correct since it is more important. We could arrive at the answer by analyzing the answer options. So, this is a direct question. Question number 15 is about the accepted test for bias. That is, if a party approaches the court saying that there has been a situation of bias, which of the options is a test of bias that the court will invoke? This is actually an external question since this test is based on a decision by a British court from 2001. The test was that if a fair-minded and informed observer who is not a party to the case and not affiliated or related to either parties considers the details of the situation and concludes that there is a real possibility or a real danger of bias, then it can be accepted as a likelihood of bias. If you are aware of this case or this test for bias, then you can answer this question directly. Even otherwise, you can use the elimination process by evaluating all the answer choices. Option D says likelihood of bias as perceived by persons involved in similar trade. While persons involved in similar trade may be well informed about the details, are they really fair-minded? They may have an affiliation to one of the parties since they are engaged in a similar trade and may sympathize with that party, and this may affect their opinion. So D may not be impartial and option D can be eliminated. Option C says likelihood of bias as perceived by a third person. This may be partially correct, but the key factor that is missing here is that whether the third person is actually informed and aware of the situation. That is this third person even capable of objectively evaluating and understanding the situation? So, an uninformed third person is not a reliable test for bias. Option B says fair-minded, which is correct, but uninformed, this is incorrect. The correct answer is therefore option A. That is, if a fair-minded and informed observer perceives the likelihood of a bias, then the court can accept that there is a possible bias. And since we can identify the correct answer by just analyzing the answer options, this is also a direct question. In the next part, I will cover passage 4 and the associated questions. I would recommend that you should read the passage, the source, and also attempt the 5 questions on your own so that you are better prepared for our discussion. You can also go to lawmen.com and check out the CLAT PG mock test series for the next exam, which includes all the CLAT PG previous papers including this one, and both new and old pattern mock tests for CLAT PG and other LLM entrance preparation. You can also attempt a free full-length mock test to get a feel of the series. I will see you soon in the next video. Jai Hind.